So good day everyone, we are the group 7 and we are here to discuss about the contents of 1987 Philippine Constitution. Now let me introduce to you the members of the group 7. So first one is Maria de Savi de Loyola, the second one is yours truly, Miss Jocelyn G. Cañete, and the third one is Mr. Benz Clarence Torrejos, and the fourth one is Miss Karil Keith Kadampog. Now, I will give the virtual floor to Ms. Desavid de Loyola to discuss about the Article 6, or also known as the Legislative Department.
So, at this very moment, we are going to talk about the Article 6, which is the document that summarizes the key provisions of the 1987 Philippine Constitution regarding the Legislative Department. So, in Article 6, it discusses the composition and powers of the Senate and the House of Representatives, the qualifications for senators and the representatives, the terms of office, and of course, the term limits. So the Article 6 composes or contains 32 sections, which we are going to talk about right now. So the Section 1 of the Article 6 is that the legislative power shall be vested in the Congress of the Philippines, which shall consist of a Senate and the House of Representatives, except to the extent reserved to the people by the provision on initiative and referendum. So the definition of legislative power, rather, is the authority to make laws and to alter or repeal them. So under the Section 1 is the classification of legislative power, which is the ODCO. So O stands for original, which means possessed by the people in their sovereign capacity, and the DE, or delegated, possessed by Congress and other legislative bodies by virtue of the Constitution, while C stands for constituent, means the power to amend or revise the Constitution, and lastly, O, which stands for ordinary, which means the power to pass ordinary laws. So in Section 1, the original legislative power of the people is exercised via initiative and referendum. So in this manner, people can directly propose and enact laws or approve or reject any act or law passed by Congress or a local government unit. Okay, so let's proceed to the next section. So the sections 2, 3, and 4 under the Article 6 states the Senate composition, which will be 24 senators who shall be elected at large by the qualified voters of the Philippines as may be provided by law. So under these three sections, which is the 2, 3, and 4, there we have the qualifications of the senators, the term limits, the term office, written. So the next section is section 5, 6, and 7, which contains the House of Representatives composition, the same with the sections 2, 3, and 4, the qualifications of the House Representatives, the term office, and of course, the term limitations. So the next section, which is the section 8 of the Article 6, it states that unless otherwise provided by law, the regular election of the senators and the members of the House of Representatives shall be held on this second Monday of May. Okay, so let's proceed to the section 9. So in section 9, it is stated that in case of vacancy in the Senate or in the House of Representatives, a special election may be called to fill such vacancy in the manner prescribed by law, but the senator or the member of the House of Representatives thus elected shall serve only for the unexpired term. Okay, so now let's proceed to the section 10 of Article 6, which contains the salaries of senators and members of the House of Representatives. So under the section 10 stated the determination of salaries. So the salaries of senators and members of the House of Representatives shall be determined by law. So there is a rule on increase in salaries where there is no increase in their salaries shall take effect until after the expiration of the full term, not tenure, of all the members of the Senate and the House of Representatives approving such increase. So let's take note that since the Constitution provides for rules on salaries and not on emoluments, our distinguished legislators can appropriate for themselves other sums of money such as travel allowances as well as other side benefits. Okay, so moving on to section 11, which is the congressional immunities. So under the section 11, it is stated the immunity from arrest of the legislators, and of course the legislative privilege and the limitation on the privilege. So under the immunity from arrest, legislators are privileged from arrest while Congress is in session with respect to offenses punishable by up to 6 years of imprisonment. So if Congress is in recess, members thereof may be arrested, or the immunity is only with respect to arrest and not to prosecution for criminal offenses. So the legislative privilege of Section 11 is that no member shall be questioned or held liable in any forum other than his or her respective congressional body for any debate or speech in the Congress or in any committee thereof. And the limitation on this privilege is that protection is only against forum other than Congress itself. So the speech or debate must be made in performance of their duties as members of Congress, and Congress need not be in session when the utterance is made, as long as it forms part of legislative action. So let's move on to Section 12 of Article 6. So the Section 12 states that all members of the Senate and the House of Representatives shall, upon assumption of office, make a full disclosure of their financial and business interests. So they shall notify the House concerned of a potential conflict of interest that may arise from the filing of a proposed legislation of which they are authors. So moving on to another section, which is the section 13 and 14. So the section 13 and 14 of Article 6 states the congressional disqualifications. So the qualifications there stated is that the senator or member of the House cannot hold any other office or employment in the government or any subdivision, agency of instrumentality thereof, including GOCCs or other subsidiaries. So this is, or the disqualification is applicable during his term. If he does so, he forfeits his seat. So the second disqualification of under the section 13 and 14 is that legislators cannot be appointed to any office. So if the office was created or the emoluments thereof increased during the term for which he was elected. And then legislators cannot personally appear as counsel before any court of justice, electoral tribunal, quasi-judicial, and administrative bodies. Then lastly, legislators cannot be financially interested directly or indirectly in any contact with or any franchise or special privilege granted by the government or any subdivision, agency, or instrumentality thereof, including any GOOC or GOCC or its subsidiary. So let's move on to the section 15, which states the regular and special sessions. So under the section 15 is the regular sessions, which the Congress convenes once every year on the fourth Monday of July unless otherwise provided for by law, and continues in session for as long as it sees fit until 30 days before the opening of the next regular session, excluding Saturdays, Sundays, and legal holidays. So this sessions under the section 15 is called by the President at any time when Congress is not in session. So moving on to section 16, which states the officers. So there we have the Senate President, the Speaker of the House, and each House may choose such other officers as it may deem necessary. So there would be, under the section 16 status, the election of officers, the quorum to do business, the internal rules, the discipline, the congressional journals and records, the adjournments. Then, to section 17 of Article 6 is the electoral tribunal, where the Senate and the House shall each have an electoral tribunal which shall be composed of 3 Supreme Court justices to be designated by the Chief Justice and 6 members of the Senate or House as the case may be. So the senior justice in the electoral tribunal shall be its chairman. So note that under section 17, the congressional members of the 80s shall be chosen on the basis of proportional representation from the political parties and party list organizations. And also the issues regarding the electoral tribunals. So let's move on to the section 18 of Article 6, which is the Commission on Appointments. So under the section 18, there we have the composition that Senate President as ex officio chairman, the 12 senators, and the 12 members of the House. So the 12 senators and the 12 representatives are elected on the basis of proportional representation from the political parties and party list organizations. So the chairman shall only vote in case of a tie. So the CA shall act on all appointments within 30 session days from their submission to Congress, and the commission shall rule by a majority vote of all the members. There we have also the jurisdiction, that Congress cannot by law prescribe that the appointment of a person to an office created by such law shall be subject to confirmation by the CA. So moving on to section 19 of Article 6, that states that the electoral tribunals and the commission on appointments shall be constituted within 30 days after the Senate and the House of Representatives shall have been organized with the election of the President and the Speaker. So the commission on appointments shall meet only while the Congress is in session at the call of its chairman or a majority of all its members to discharge such powers and functions as are herein conferred upon it. So the section 20 of Article 6 states the transparency of records. So the section 20 stated that the records and books of accounts of the Congress shall be preserved and be open to the public in accordance with law, and such books shall be audited by the Commission on Audit, which shall publish annually an itemized list of amounts paid to and expenses incurred for each member. So let's move on to the next section. So the sections 21 and 22 states the legislative inquiries. So there we have under the sections 21 and 22 the scope, the enforcement, the limitations, the appearance by department heads before Congress, where since members of the executive department are co-equals with those of the legislative department, under the principle of separations of powers, department heads cannot be compelled to appear before Congress, neither may the department heads impose their appearance upon Congress, and so on. Then the sections 23 and 24 states the declaration of war or emergency powers. So there were under the sections 23 and 24 that the vote requirement is to declare the existence of a state of war. So 2/3 of both houses in joint session and the voting separately. So there we have the under the section 23 and 24 stated the emergency powers, which are first, during times of war or other national emergency, Congress may, by law, authorize the President to exercise powers necessary and proper to carry out a declared national policy. Secondly, the limitations, which are the powers will be exercised for a limited period only, and powers will be subject to restrictions prescribed by Congress. Then lastly, the expiration of emergency powers. So first, by resolution of Congress, or second, upon the next adjournment of Congress. So the next section is the section 24, which states the legislation of bills that must originate from the House of Representatives. So we have a code on the bills. We have the Art Pulop, which A stands for appropriation bills, R stands for revenue bills, T stands for tariff bills, and PU stands for bills authorizing the increase of public debt. LO stands for bills of local application, and lastly, P stands for private bills. So, under the section 24, the Senate may, however, propose or concur with amendments. So, the next section is the section 25. So, section 25 of Article 6 states that the Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. So, the form, content, and manner of preparation of the budget shall be prescribed by law. Then, no provision or enactment shall be embraced in the General Appropriations Bill unless it relates specifically to some particular appropriation therein. So, any such provision or enactment shall be limited in its operation to the appropriation to which it relates. The next, the procedure in approving appropriations for the Congress shall strictly follow the procedure for approving appropriations for other departments and agencies. Then, A special appropriations bill shall specify the purpose for which it is intended and shall be supported by funds actually available as certified by the National Treasurer or to be raised by a corresponding revenue proposed therein. Then under section 25 also is that no law shall be passed, rather, authorizing any transfer of appropriations. However, the president, the president of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of constitutional commissions may by law be authorized to augment any item in the General Appropriations Law for their respective offices from savings in other items of their respective appropriation. And then, discretionary funds appropriated for particular officials shall be disbursed only for public purposes to be supported by appropriate vouchers and subject to such guidelines as may be prescribed by law. Then lastly, under the section 25, if by the end of any fiscal year, the Congress shall have failed to pass the General Appropriations Bill for the ensuing fiscal year, the General Appropriations Law for the preceding fiscal year shall be deemed reenacted and shall remain in force and effect until the General Appropriations Bill is passed by the Congress. So let's move on to the section 26. So the section 26 stated that every bill passed by the Congress shall embrace only one subject which shall be expressed in the title thereof. And then secondly, no bill passed by either house shall become a law unless it has passed 3 readings on separate days and printed copies thereof in its final form have been distributed to its members. So except when the President certifies to the necessity of its immediate enactment to meet a public calamity or emergency. So upon the last reading of a bill, no amendment thereso shall be allowed, and the vote thereon shall be taken immediately thereafter, and the years and days entered in the journal. Then we have the section 27, which states that every bill passed by the Congress shall, before it becomes a law, be presented to the President. So if the President approves the same, he shall sign it. Otherwise, he shall veto it and return the same with his objections to the House where it originated, which shall enter the objections at large in its journal and proceed to reconsider it. So if, after such reconsideration, 2/3 of all the members of such House shall agree to pass the bill, it shall be sent, together with the objections, to the other House, by which it shall likewise be reconsidered, and if approved by 2/3 of all the members of that House, it shall become a law. So in all such cases, the votes of each House shall be determined by yeas or nays, and the names of the members voting for or against shall be entered in its journal. So the President shall communicate his veto of any bill to the House where it originated within 30 days after the date of receipt thereof, otherwise it shall become a law as if he had signed it. Okay, so next section will be the section 28. So section 28 states the power to tax. So there we have that the rule of taxation should be uniform and it should be equitable. So Congress should evolve a progressive system of taxation. So the power to tax must be exercised for a public purpose because the power exists for the general welfare, and the due process and equal protection clauses of the Constitution should be observed. So under the section 28 of Article 6 is also written the delegation of power to fix rates and the constitutional tax exemptions. So moving on to the next section, and that would be section 29, which stated the power of the purse. So section 29 stated that no money shall be paid out of the treasury except in pursuance of an appropriation made by law. Then secondly, no public money or property shall be appropriated, applied, paid, or employed, directly or indirectly, for the use, benefit, or support of any sector, church, denomination, sectarian institution, or system of religion, or any priest, preacher, minister, or other religious teacher or dignitary as such, except when such priest, preacher, minister, or dignitary is assigned to the armed forces or to any penal institution or government orphanage or leprosarium. And then lastly, under the section 29 is that all money collected on any tax levied for a special purpose shall be treated as a special fund and paid out for such purpose only. So if the purpose If the purpose rather for which a special fund was created has been fulfilled or abandoned, the balance, if any, shall be transferred to the general funds of the government. And let's move on to the section 30 of Article 6, which states that no law shall be passed increasing the appellate jurisdiction of the Supreme Court as provided in this Constitution without its advice and concurrence. And then section 31 states that no law granting a title of royalty or nobility shall be enacted. And then lastly, section 32 states that the Congress shall as early as possible provide for a system of initiative and referendum in the exceptions therefrom, whereby the people can directly propose and enact laws or approve or reject any act or law or part thereof passed by the Congress or local legislative body after the registration of a petition, therefore signed by at least 10% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters thereof. Okay, so that's all for the Article 6. Then I will give the floor to Miss Jocelyn to proceed to another article. Thank you.
Well, good day, everyone. I'm Jocelyn Cañete. I'm one of the reporters for this group. So, the task that I'm assigned to is the Article 7, or also known as the Executive Department. So, now let's proceed to the Section 1. So, the Section 1 is all about the executive power. So, the executive power shall be vested in the President of all the Philippines. So the Section 1, Article 7 in the Philippine Constitution states that the executive power, that the power is vested in the President of the Philippines. So this means that the President holds the primary authority to enforce laws, manage the operations of the government, and represent the nation in official matters. Now let's proceed to the section 2. So the section 2 is all about the qualification to become a president. So to be a president, you should be a natural born citizen from the Philippines and a registered voter and able to read and write and at least 40 years of age on the day of the election and also a resident of the Philippines for at least 10 years immediately preceding the election. So that's all for the section 2, and the section 2 is all about the qualification. Now let's proceed to the section 3 of the Article 7. So the section 3 is all about there shall be a vice president who shall have the same qualifications and term of office and be elected with and in the same manner as the president. He may be removed from the office in the same manner as the president. So the executive branch of the government include the vice president. So the vice president must meet the same qualification as the president, serve the same length of time on office, and be elected alongside the president in the same election process. If necessary, the vice president can be removed from the office using the same procedure that apply to the president. So that's all for the section 3 of the Article 7. Now let's proceed to the section 4, or also known as the term of office. So the section 4 is all about the president and the vice shall be elected by the people for 6 years, and the president shall not be eligible for any re-election. No person who has succeeded as president has served as much as such for more than 4 years shall be qualified for election to the same office at any time. So, regular election, vice and president shall be held on the second Monday of May. After every presidential and vice presidential election, the certified election returns from each province or a city are sent to the president of the Senate. So within 30 days of the election, the Senate president must open all the certificates in a joint public session of the Senate and the House of Representatives. The next one is Congress will then verify the authenticity and the proper execution of the certificate and canvass the votes. The candidates with the highest number of votes is declared elected. So if there is a tie, the Congress will select one of the tied candidates by a majority vote of all members from both houses voting separately. So the president and the vice president are elected by the people for a term of 6 years. So the president cannot be re-elected after serving one term. If someone becomes the president and serve for more than 4 years, they cannot run for president again. So election for the president and the vice president takes place every 6 years on the second Monday of May. So after the election, official results from each province or city are sent to the president of the Senate. So within 30 days, the president must open this result in a public session attended by both the Senate and the House representatives. So then, the Congress will check the result to ensure they are valid and account the votes. So the candidates with the most votes wins. So if there is a tie, the Congress will vote to decide the winner. So with members of the Senate and the House of Representatives voting separately. So that's all for the section 4 of the Article 7. Now let's move on to the section 5. Now, for the section 5 of the Article 7, it's all about the oath of office. So before they enter on the execution of their office, the president and the vice president or the acting president shall take a following oath of affirmation. So so this section of the executive department or Article 7 talks about that what the president, vice president or acting president has to do before they start doing their job. So they have to say a promise called an oath or affirmation. It's like making a serious promise in front of others. This promise is important because it shows that they are committed to doing their job well and following the rules of the position. It's a way of saying, I promise to do my best and be honest while doing my job. So before they start working, they have to say this promise to show they're ready to take on their responsibility to becoming a president, the vice president, and the acting president. So that's all for the section 5. Now let's proceed to the section 6. Now, for the section 6 of the Article 7, the Executive Department, it's all about the President shall have an official residence. The salaries of the President and Vice President shall be determined by law and shall not be decreased during their tenure. No increase in said compensation shall take effect until the expiration of the term of the incumbent during their such increase was approved. The next bullet, they shall not receive during their tenure any other emolument from the government or any other source. So, this section of the executive department deals with the president and vice president official residence and their salaries. So, let's first go to the first bullet, the official residence. So, the president needs a place to live and work. So, this section says they must have an official home provided by the government. So, here in the Philippines, it's called the Malacanang Palace. So for the next bullet, the salaries. So the salaries, the president and the vice president pay is decided by the laws made by the government. Once their salaries are set, they can't be reduced while they're in the office. But if there is an approved increase in their pay, it can happen until after they finish their term. So for the next bullet, no other payment. So while they are in the office, the president and the vice president can get any other money or benefits from the government or anywhere else. Their salary is their only income from their time in the office. So that's it for the section 6. Now let's proceed to the section 7 of the article 7. So the section 7 is all about the president-elect and the vice president-elect shall assume office at the beginning of their terms. President-elect fails to qualify, the vice president-elect shall act as the president until the president-elect shall have qualified. If at the beginning of the term, the president and the president-elect shall have died or shall have become permanently disabled, the vice president-elect shall become a president. So this section basically talks about what happens if something goes wrong with the president-elect or the person who has been chosen to become the president but hasn't officially started yet is supposed to take the office. So let's explain this one by bullet. So the first bullet is president-elect and the vice president-elect taking office. So it says that the president-elect The president-elect and the vice president-elect start their job as soon as their terms begin. So the next bullet is all about the president-elect can take office. So if the president-elect can do their job for some reason, like they don't meet the requirements or something else happens, then the vice president-elect step in and act as the president until the president-elect can do the job properly. So for the next bullet is all about the president-elect dies or is permanently disabled. So if at the start of the president's term the president-elect has died or is permanently unable to do the job, so the vice president-elect becomes the president instead. So basically, this section lays out what happens if the person who is supposed to become the president can't do the job for some reason. So that's all for the section 7. Proceed to the section 8 of the article 7. So in case of death, permanent disability, removal from the office, or resignation of the president, the vice president shall become the president to serve the unexpired term. So the second bullet, president and the vice president, president of the Senate, or in case of instability, the Speaker of the House of the Representatives shall then act as a president until the president of the vice president or the vice president shall have been elected and qualified. So this section of the executive department outlines what happens if something happens to the president while they're in the office. If the president dies, becomes permanently disabled, is removed from office or resign, the vice president takes over and become the president for the rest of the term. So during this time, if the vice president becomes the president of the Senate, which is the person in the Congress, or if they can't do it, then the president of the House Representatives or another person in Congress will temporarily take on the role of the president until a new president or vice president is elected and ready to take over. Now, let's proceed to the section 9 of the Article 7. So, whenever there is a vacancy in the office of the vice president during the term of which he was elected, the president shall nominate a vice president from among the members of the Senate and the House of the Representatives, who shall assume office upon confirmation by a majority of both of all the members of both houses of the Congress voting separately. So, this section of the Constitution talks about what happens if the vice president position becomes empty while they're still supposed to be in the office. So if this happens, the president rather get to choose a new vice president. So the president picks someone from the Senate or the House of the Representatives to the new vice president. But that's not all. So before this new vice president can start their job, they need to be approved by both the Senate and the House of the Representatives. They need more than just a regular vote though, but they need a majority both, meaning most of the members from both the Senate and the House of the Representatives need to say yes to this new vice president. So, if the vice president's seat is empty, the president picks someone from the Congress, and that person needs to be approved by most of the members in both the Senate and the House of the Representatives before they can officially become the vice president. So that's all for the section 9 of the Article 7. Now let's proceed to the section 10 of the Article 7. So the bill shall be deemed certified and shall become law upon its approval in the third reading by Congress. The convening of the Congress cannot be suspended nor the special election postponed. So no special election shall be called if the vacancy occurs within 18 months before the date of the next presidential election. So this section of the Executive Department, Article 7, talks about how a bill becomes a law in the Philippines. So when Congress approves a bill on its third reading, it's considered certified and become a law once it's approved. So this means that the president or the other approving authority has given it the green light. So the second part of this section talks about special election and Congress meetings. So it says that the Congress meetings can be stopped or special election delay. So this means that the important governmental process keep going even if something unexpected happen. So also it mentioned that a special election won't be held if someone leaves their position within 18 months before the next presidential election. So this rule avoid unnecessary expenses and keeps the focus on the regular election schedule. So that's all for the section 10. Now let's proceed to the section 11. Now let's proceed to the section 11 of the Article 7. So presidential inability and succession, or also known as the section 11. So temporary transfer of power to the vice president. So there are two: the voluntary transfer. When the president declares in writing that he cannot perform his duties, the vice president becomes an acting president until the president declares he can resume his duties, or the involuntary transfer. If the majority of the cabinet declares the president unable to perform his duties, so the vice president becomes acting president immediately. So let's explain this Article 7, Section 11 of the Executive Department in simpler terms. So the presidential inability and succession. So this section deals with what happened if the president is unable to carry out their duties. So, temporary transfer of power to the vice president. So, if the president can do their job for some reason, the vice president steps in temporarily. So, there are two transfer here. The voluntary is what I mentioned earlier. So, the voluntary transfer, if the president admits in writing that they can do their job, the vice president takes over until the president says they can do their job again. So, the next transfer is the involuntary transfer. So if most of the president's cabinet or the group of people who help the president make decision says that the president can do their job, the vice president immediately becomes acting president. In simpler terms, if the president can do their job, the vice president takes over when the president says so or when the cabinet says so. So that's it for the section 11 of the Article 7. Now let's proceed to the section 12 of the Article 7. So the section 12 is all about in case of serious illness of the president, the the public shall be informed of the state of his health. The members of the cabinet in charge of the national security and foreign relation and the chief of staff of the armed forces of the Philippines shall not be denied access to the president during such illness. So this section of the Executive Department, Article 7, deals with what happens if the president gets seriously ill. So it says that if the president is very sick, the public should be told about how sick they are. So during this time, certain important people like the members of the cabinet who are responsible for the national security and dealing with other countries, as well as the chief of staff of the armed forces of the Philippines must be allowed to see the president. They can't be stopped from visiting the president during their illness. So that's all for the section 12 of the Article 7. Now let's move on to the section 13 rather. So for the section 13, it's all about the prohibited activities for the executive official. So prohibition on holding other position. So the president and vice president, cabinet members, and their deputies or assistants cannot hold any other office or employment during their tenure unless the constitution provide otherwise. So the first restriction is restriction on professional and business activities. So this official cannot practice any other profession or engage in business activities. They must avoid financial interest in government contract, franchise, or special privileges granted by the government or its entities. So they must strictly avoid any conflict or interest in their official conduct. So the next restriction is restriction on relatives. So the president's spouse and relatives up to fourth degree cannot be appointed to key government position during the president tenure. So I'll explain this. So this section of the executive department rules outlines what government official like the president, vice president, and the cabinet members can and cannot do while they're in the office. First, it says that they can take on any other job or role besides the one they have in the government. So they need to focus on their government duties. Second, they are not allowed to work in any other profession or start a business while they're in the office. So they need to avoid situations where their jobs in the government might mix up while with their personal interest. Third, they cannot have any financial interest in the government deals or special favors. So this means they can make money from the government contract or special permission given by the government. Fourth, they have to be very careful about conflicts or interests. So they shouldn't do anything in their government role that might benefit them personally. Lastly, the president family members, like their spouse and close relatives, can be given important government jobs while the president is in charge. This is to avoid any accusation of favoritism or nepotism. So that's all for the section 13 of the Article 7. To the Section 14 of the Article 7. Appointment extended by an acting president shall remain effective unless revoked by the elected president within 90 days from this assumption or reassumption office. So this section basically says that if someone temporarily takes over as president, called an acting president, any appointments they make will stay effect unless the real elected president decide to cancel with them within 90 days after they start their job. So if the acting president appoints someone to a position, it says that way unless the real president says otherwise within 3 months of taking office again. So that's it for the section 14. Now let's proceed to the section 15 of the Article 7. So, 2 months immediately before the next presidential election and up to the end of his term, a president or acting president shall not make appointment except temporary appointments to executive position when continued vacancy therein will be prejudiced public service or endangered public safety. So this section of the executive department or Article 7 deals with what a president or acting president can do in the 2 months leading up to the presidential election and until the end of their term in the office. So basically, during this time, they are not allowed to make any appointments to important government job unless it absolutely necessary for smooth of the running of the government or the public safety. So this means they can only make temporary appointments to fill position if leaving them empty would cause problems for the position if leaving for the government or put people's safety at risk. So it's like a rule to prevent any last minute rush decision that could affect the government functioning. So that's all for the section 15. Now let's proceed to the section 16. So Congress can pass laws to delegate appointments, powers to the president, courts or heads or departments, agency, commission or boards. President can make appointments during congressional recess, but they are temporarily subject to confirmation by the commission on appointment or until the next congressional adjournment. So, let's explain this one by one bullet. So the first bullet is all about Congress can delegate appointment power. So this means that the Congress can give the power to the appoint certain people for government position to different authorities like the president, courts or heads of departments or agency, commission or boards. So the next bullet is all about the president recess appointments. So if the Congress is on break or the recess, the president can still choose people for certain position temporarily without needing Congress approval. However, these appointments are only temporary until either the commission on appointment confirms them or until Congress come back from the recess. So basically, this section explain how appointments for government position can be made by the different authorities, and it outlines the process for temporary appointments with the president during congressional breaks. So that's it for the section 16. Now let's proceed to the section 17. So the section 17 is all about the president shall have control of all the executive department, bureaus, and offices. He shall ensure that the laws be faithfully executed. So this section of the Article 7 of the executive department in the Constitution talks about the president's power and responsibility. It says that the president is in charge of all the different parts of the executive branch, like the department, bureaus, and the offices. So the main job of the president is to make sure that the laws of the country are followed properly. This means that they need to see that the laws are carried out or executed correctly. So that's all for the section 17. To the section 18 of the article 7. So the section 18 is all about the president serve as the commander in chief of all armed forces in the Philippines and can deploy them to prevent or suppress lawless violence, invasion or rebellion. So in cases of invasion or rebellion or threatening public safety, the president can declare martial law or suspend the writ of habeas corpus for up to 60 days with a mandatory report to Congress within 48 hours. So Congress, by a majority vote, can revoke such proclamations or suspension with the president unable to overturn it. So if the Congress is not in session, it must convene within 24 hours after the proclamation or suspension. So the Supreme Court can review the factual basis of the martial law or habeas corpus suspension upon filing by any citizen issuing a decision within 30 days. Martial law doesn't nullify the Constitution, civil courts, or the legislative assemblies, nor does it grant military court jurisdiction or over civilians where civil courts function, nor automatically suspend habeas corpus. Habeas corpus suspension applies only to those judicially charged for rebellion or related offenses. Anyone arrested or detained during the suspension must be judicially charged within 3 days or they must be released. So, this section talks about the power of the president during their times of trouble, like when there's a serious threat to the country's safety, such as invasion, rebellion, or big violent acts. So let's break it down into pieces, or let's explain this one by one. So the first bullet is all about the commander in chief. The president leads all the armed forces of the Philippines. They can use these forces to stop violence, invasion, or rebellion. So for the second one is martial law and habeas corpus suspension. So if there is a big invasion or rebellion that puts people in danger, if the president can declare a martial law, this means the military takes control temporarily. The president can also suspend habeas corpus, which is a legal rule that protects people from being held in the jail without good reason. But this action can only last for up to 60 days. So Congress check for the third bullet. Congress, which is made up of elected officials, can stop the president martial law or habeas corpus suspension if most of them agree. So even if the president says it should continue, Congress can still say no. So for the next bullet, Supreme Court review. So the highest court in the land, the Supreme Court can check if the president had a good reason for declaring a martial law or suspending habeas corpus. Any citizen can ask the Supreme Court to do this. So the Supreme Court has to decide within 30 days if the president's reason were right or not. So for the next one, limits of martial law. So martial law doesn't mean the constitution regular courts or lawmakers stop working. Military courts can take over unless the regular court can do their job properly. And suspending habeas corpus doesn't mean everyone loses their rights. So it only applies to people who are being charged with rebellion or related crimes. So for the last bullet, rights of the arrested. If someone gets arrested or held during martial law or habeas corpus suspension, they have to be charged with a crime within 3 days. If not, they have to set they have to be set free. So this rule makes sure people aren't held unfairly for too long. So overall, these rules aim to balance the president power to protect the country with making sure people rights are still respected even in tough times. So that's all for the section 18. Now let's proceed to the section 19 of the Article 7. So, except in any cases of impeachment or as otherwise provided in this Constitution, the President may grant reprieves, commutation, and pardons and remit fine and forfeitures after conviction by a final judgment. He shall also have the power to grant amnesty with the concurrence of a majority of all members of the Congress. So, this section of the Constitution talks about the power of the President, specifically regarding pardons and amnesty. So, first it says that the President can pardon, reduce the punishment, or completely forgive someone who has been convicted of a crime, except in cases of impeachment. So, if someone has been found guilty of a crime by a court, the president can decide to let them off the hook, so to speak. Secondly, it mentioned amnesty. Amnesty is like a pardon, but it's for a group of people for a particular type of offensive. However, the president can't do this on their own. They need agreement of the members of Congress to grant amnesty. So it's a decision that requires both the President and the Congress to agree. So in simpler terms, this section gives the President the power to forgive individual criminals or groups of people for their crimes. But for amnesty, they need to get the nod from the Congress. So that's it for the section 19. Now let's proceed to the section 20. So the section 20, the president is authorized to contact or guarantee foreign loans for the Philippines, but this require prior approval from the Monetary Board, and this subject to legal limitation. The Monetary Board must provide a comprehensive report to the Congress every quarter regarding its decision on loans application that would increase the foreign debt of the government or government owned and controlled corporations. So this report must be submitted within 30 days from the end of each quarter and should be include other relevant details as prescribed by the law. So this section of the Philippine Constitution talks about how the president can borrow money from the other countries or the Philippines for the Philippines. However, the president needs permission from the Monetary Board before doing so. So the Monetary Board is responsible for overseeing the country's money matters. So if the president wants to borrow money from the other country, the monetary board has to give a detailed report to the Congress every 3 months. So this report should be explained all the decision the board has to make about loans, requests that would make the government owe more money to the other countries. So it's important that the Congress gets his report within 30 days after each 3 month period end. So the report should also include other important information required by the law. So that's all for the section 20 of the Article 7. 21 of the Article 7. So the Section 21 is all about no treaty or international agreement shall be valid and effective unless concurred in by at least two-thirds of all the members of the Senate. So this section is saying that any treaty or international agreement which are like the official deals or promises between countries can't become official or actually work unless at least two-thirds of the senator agree to it. So senators are the people who help make laws and decisions for the country. So if you want to make a deal with another country, so most of the senators have to say yes to it before it can happen. So it's like needing a big majority vote among the senators to make it official. So that's all for the section 21 of the Article 7. So let's proceed to the section 22. So the Section 22 is all about the President shall submit to the Congress within 30 days from the opening of every regular session as the basis of the General Appropriation Bill, a budget of expenditure and success of financing, including receipts from existing and proposed revenue measures. So let's explain this one by one. So I also mentioned earlier the President. So this refers to the head of the country or the person elected to lead the nation. So I also mentioned submit to the Congress. The president has to give the information to the Congress, which is made up of elected representatives who make laws. So within 30 days from the opening of every regular session. So this means that the president has to do this within a month and after Congress starts its normal meetings. So as I mentioned also as the basis of the General Appropriation Bill. So this information as the President provides will be used to create a general plan for how the government will spend money. So this plan is called the General Appropriation Bill. I also mentioned that a budget of expenditure and source of financing. So the president needs to give details about how much money the government plans to spend or the expenditure and where it's going to get the money from or the source of financing. I also mentioned that including receipts and existing and power unproposed revenue measures. So this means that the president has to include information about the money the government already has or the existing revenue and any new ways they plan to get the money or the proposed revenue measures. So in simpler terms, this section of the law is saying that the president has to tell the Congress within a month of their meeting starting about how much money of the government plans to spend on and where it will came from. So this helped the Congress make decision about the country's finances. So that's all for the section 22. Let's proceed to the section 23 of the Article 7. So the President shall address the Congress at the opening of its regular session. He may also appear before it at any other time. So this section of the executive department or the Article 7 outlines the responsibility of the president regarding communication with Congress. So it says that the president must speak to the Congress at the beginning of its regular meeting. So this is called the State of the Nation address or something similar. It's like a big speech where the president talks about how important issues facing the country. So the next one, additionally, it says also that the president can also talk to the Congress at other times if needed. This means if there's something urgent or important, the president can go speak to the Congress, not just during their regular meetings. This could be discussed to the emergencies, new laws, or other important matters. That's all for the section 23 of the Article 7. So that's all for the section 7, or also known as the Executive Department. Thank you.
Article 8, which is the Judicial Department Section 1. So the judicial power shall be vested in one Supreme Court and in such lower court as may be established by law. So the country's judicial power of the authority to interpret and apply the law is given to the Supreme Court, which is the highest court. So additionally, other lower courts can be created as needed by making new law. This means that the Supreme Court has the ultimate authority, but there can also be other courts below it to handle different kinds of cases. So the judicial department, it includes the duty of the Court of Justice to settle the actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretions amounting to lack or excess of jurisdictions on the part of any branch or instrumentality of the department. So the judicial power and jurisdictions, this power includes the duty to settle actual controversies involving rights that are legally demandable and enforceable, and to determine if any branch or instrumentality of government has acted with grave abuse of discretion amounting to the lack of excess of jurisdiction. So the Section 2 of the Judicial Department, the Congress shall have the power to define, prescribe, and apportion the jurisdictions of the various courts, but may not deprive the Supreme Court of its jurisdictions over cases enumerated in Section 5 thereof. So this is the Congress has the authority to decide what type of cases different courts can handle and how they are divided. So however, Congress cannot take away the specific cases that the Supreme Court is allowed to handle as listed in the Section 5. Next is the Section 3. So the Section 3 is the judiciary shall enjoy fiscal autonomy. Appropriations for the judiciary may not be reduced by the legislature below the amount of appropriated for the previous year, and after approval shall be automatically and regularly released. So, from this section, so the judiciary, the system of courts has financial independence. This means that the money allocated to the courts cannot be decreased by the legislature compared to the previous year. So once the budget is approved, the funds must be provided automatically and consistently. The Section 4 of the Judicial Department, first, which is the Supreme Court, shall be composed of a Chief Justice and a 14 associate justices. So it may be set in rank or in its discretions and divisions of 3, 5, or 7 members. So any vacancies shall be filled within 19 days for the occurrence thereof. So second is the Supreme Court has to review cases that involve treaties, international agreements, laws, and rules made by the President. When deciding these cases, more than half of the justices who will discuss and voted in the case must be involved in the final decisions. The third is cases or matters heard by the divisions shall be decided or resolved with the occurrence of majority of the members who actually took part in the deliberations on the issues in the case and voted thereon, and in no case without the concurrence of at least 3 of such members. Next is the Section 5 of the Judicial Department. First, which is exercise original jurisdiction over cases affecting. So the Supreme Court has the authority to directly handle cases involving ambassadors, other important foreign officials like public ministers, and consuls special legal requests called petitions for certiorari prohibitions, mandamus, quo warranto, and habeas corpus. These are different types of legal actions to review lower court decisions. Topple illegal actions require officials to do their duties, challenge someone's right to hold an office, or release someone unlawfully detained. So the second is review, revise, reverse, modify, or affirm on appeal or certiorari as the law of the rules of court may provide final judgments and orders of lower. So all cases, constitutionality or validity of any treaty. Next is international or executive. Then agreement, law, presidential decree. Then proclamation, order, instruction. Next, ordinance or regulation is in question. B is all cases involving the legality of any tax, imposed, assessment, or toll, or any penalty imposed in relation thereto. C, all cases in which the jurisdiction of any lower court is in issue. Or D, all criminal cases in which the penalty imposed in reclusions perpetua or higher. Or A, all cases in which only an error or questions of law is involved. So number 3, assign temporarily judges of lower courts to other stations as public interest may require. Such temporary assignment shall not exceed 6 months without the consent of the judge concerned. So this means that the Supreme Court can temporarily assign judges from lower court to different location if needed for the public good. However, this temporary assignment cannot last more than 6 months unless the judge agrees to stay longer. 4. Order a change of venue or place of a trial to avoid a miscarriage of justice. So this means that the Supreme Court can decide to move a trial to a different locations if they believe that having in it the current location might result is an unfair outcome. This is done to make sure that justice is served properly. So number 5, promulgate rules concerning the protections and enforcement of constitutional rights, pleading practice and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. So this means that the Supreme Court can create rules that help protect and enforce people constitutional rights. They can also make rules about how court cases are conducted, including how lawyer presents their cases and the procedures followed in court. So additionally, they can make rules about who can become a lawyer, how the legal profession is organize and provide legal assistance to those who cannot afford it. Number 6 is appoint all officials and employees of the judiciary in accordance with the civil service law. So this means that the Supreme Court is responsible for selecting and hiring all the people who work for the courts. So they do this following the rules and regulations outlined in the civil service law, which sets the standard for hiring and employment in the government's agencies. The Section 6. The Supreme Court shall have administrative supervisions over all courts and the personnel thereof. So this means that the Supreme Court is in charge of overseeing the operations of all courts and their staff members. So this means that they have the authority to make sure that courts are running smoothly and efficiently and that the people who work in the courts are doing their jobs properly. Section 7. First, no person shall be appointed member of the Supreme Court or any lower collegiate court unless he is natural-born citizen of the Philippines, must be at least 40 years of age. And
Now let's proceed to the Article 9, or also known as the Constitutional Commission. So the A here is to be discussed by me, and the B is to be discussed by Mr. Benz, and the C and D is to be discussed by Miss Caril. So let's proceed to the Section 1. So the Section 1 is all about the Constitutional Commission, which shall be independent, are the Civil Service Commission, the Commission on Election, and the Commission on Audit. So the Section 1 are also known as Common Provision. So this section establishes the three independent constitutional commission: the Civil Service Commission, or the CSC, the Commission on Election, or the COMELEC, and the Commission on Audit, or the COA. So these three commission are tasked with specific function related to the civil service election and auditing government expenditure respectively. Now let's proceed to the section 2. So members of Constitutional Commission cannot hold any other office or employment while in the office. They are prohibited from practicing any other profession or actively managing any business that could be influenced by their commission function. Additionally, they cannot have an financial interest, direct or indirect, in contracts, franchises of or privileges granted by the government or its agencies, including government-owned or controlled corporation. So the section 2 is all about the membership restriction. So members of the Constitutional Commission are subject to several restrictions, ensure their independence and impartiality. So they cannot hold any other office or employment while serving in their commission. So furthermore, they are prohibited from engaging in any profession or businesses that could be influenced by the function or of their commission. Additionally, they cannot have any financial interest, whether direct or indirect, in government contract, franchises, or privileges. Now let's move on to the section 3, or the section 3 is all about the salary of the chairman and the commissioner shall be fixed by the law and shall not be decreased during their tenure. So the section 3 is all about salary fixation. So this section ensures that the salary of the chairman and the commissioners of the Constitutional Commission are fixed by the law and cannot be decreased during their tenure. So this provision is aimed at safeguarding the independence of this official from political influence or pressure. Now that's all for the section 3. Now let's move on to the section 4. So the section 4 is all about the Constitutional Commission shall appoint their official and employees in accordance with law. So section 4 is all about appointment authority. So the Constitutional Commission have the authority to appoint their official and employees in accordance with the law. So this provision grants them autonomy in staffing their respective offices, allowing them to select individuals based on the merit and suitability for the positions. Section 5. So the Section 5 is all about the Commission shall enjoy fiscal autonomy. Their approval annual appropriation shall be automatically and regularly released. So Section 5 is all about the fiscal autonomy. So each constitutional commission is granted with fiscal autonomy, meaning that their approved annual appropriation must be automatically and regularly released. So this provision ensures that the Commission have the necessary financial resources to carry out their function independently without being subject to undue influence or interference. Now let's proceed to the section 6. So section 6 is all about each commissions in bank may promulgate its own rules concerning pleadings and practice before it or before any of its offices. Such rules, however, shall not diminish, increase, or modify substantive rights. So section 6 is all about rule-making authority. So this section grants each constitutional commission the authority to promulgate its own rules concerning pleadings and practice before it or any its office. However, these rules must not diminish, increase, or modify substantive rights. Essentially, the Commission have the power to establish procedural guidelines for operations, but they cannot alter the substantive rights of individuals or entities subject to their jurisdiction. That's it for the A, or also known as the common provision in the Article 9.
C is the Commission in Elections, Section 1. So first, the Commission on Elections will consist of chairman and 6 commissioners, so all natural-born citizens, college-educated, and not candidates for previous elections, with a majority of being members of the Philippine Bar. The second is the court has exclusive original jurisdictions over elections, returns and qualifications for elective officials, and appellate jurisdictions over municipal and barangay officials cases. So this means the Commission on Elections or COMELEC is the main authority responsible for handling matters related to elections, including deciding on the results and qualifications of elected officials. It has the power to handle cases involving municipal and barangay officials on appeal, which means reviewing decisions made by the lower courts or the bodies regarding this official. So the third is the committee will determine all election-related questions except those pertaining to voting rights, such as polling place, number and locations, appointment of elections officials, and voter registrations. So these sections outlines the responsibilities of the commissions of elections or the COMELEC. The COMELEC is the tasked with deciding all issues related to elections, except for matters concerning voting rights. Specifically, it is responsible for determining questions related to elections, such as the conduct of the elections, the appointment of elections officials, and voter registrations. However, decisions about voting rights, such as where polling places are located and how many there are, not within its jurisdiction. So therefore, the President will appoint law enforcement agencies and government instrumentalities, including the armed forces, to ensure free, orderly, honest, peaceful and credible elections. So the section states that the President is responsible for appointing law enforcement agencies and government bodies, including the armed forces, to guarantee the elections are conducted freely, orderly, honestly, faithfully, and credibly. So number 5, the commissions on elections must register political parties and organizations or coalitions after publications, excluding religious denominations, those using violence, or those supported by foreign governments. Financial contribution from foreign governments to political parties or candidates can result in their registrations being cancelled, along with other penalties. So number 6, the organization files petitions for voter inclusions or exclusions, investigates and prosecutes cases of elections law violations, including frauds, offenses, and malpractices upon verified complaints. So these sections outline the duties of the commissions on elections or the COMELEC. So the COMELEC is the responsible for handling petitions regarding the inclusions or exclusion of voters from the voters list. It also investigates and prosecutes cases related to violations of elections law, such as fraud offenses and malpractice when complaints are verified. So number 7, recommend to the Congress effective measures to minimize election spending, including limitation of places where propaganda materials shall be posted, and to prevent and penalize all forms of election frauds, offense, malpractices, and nuisance candidates. So this section specifies that the Commission on Elections or COMELEC is tasked with suggesting to the Congress ways to reduce election spending. So this includes proposing limits on where campaign material can be displayed. Additionally, the COMELEC is responsible for recommending measures to prevent and punish various types of elections related to wrongdoing, such as fraud, offenses, malpractice, and candidacy of individuals who disrupt the electoral process without serious intent or nuisance of candidate. So number 8, recommend to the President the removal of any officer or employees it hath deputized or the imposition of any other disciplinary actions for violations or disregard of or disobedience to its directive, order, or decision. So the Commission on Elections or COMELEC has the authority to suggest to the President of the dismissal or any officer or employee it has deputized or recommend other disciplinary actions if they are violate or ignore its instructions, orders, or decisions. Number 9, submit to the President and the Congress a comprehensive report on the conduct of each elections, plebiscite, initiative, referendum, or recall. So after every elections, plebiscite, initiative, referendum, or recall process, the COMELEC is required to prepare and submit a detailed report to both the President and the Congress, providing to comprehensive overview on how the event was conducted. Next is the Section 3. The Commission on Election can sit in bank or in the two divisions implementing rules to expedite elections case dispositions, including proclamations, controversies, with motions for reconsideration decided by the commissions in bank. So this section outlines the functioning of the commissions on elections, COMELEC or COMELEC. The COMELEC can operate either as a whole body or divide into two smaller groups or divisions. It has the authority to create rules aimed at speeding up the resolutions of elections-related cases, including disputes before the official announcement of winners. Or any motions for reconsiderations regarding these cases will be decided by the entire commission acting as a whole. In Section 4. The Commission can oversee and regulate transportations, public utilities, and communication grants during elections, ensuring equal opportunity, time and space for public informations, campaigns, and forums. This is to ensure free, orderly, honest, faithful, and incredible elections. So this section specifies that the commissions on elections or COMELEC has the authority to supervise and regulate transportations, public utilities, and communications facilities during elections. It ensures that there is equal opportunity, time, and space for public informations, campaigns, and forums. These measures are put into place to guarantee that elections are conducted freely in an orderly manner, honestly, faithfully, and are deemed credible by the public. Section 5. No pardon, amnesty, parole, or suspension of sentence for violations of elections, law, rules, and regulations shall be granted by the President without the favorable recommendations of the commissions. So this section states that the President cannot grant pardons, amnesties, paroles, or suspend sentences for individual convicted or violating election law, rules, and regulation without the favorable recommendation of the commissions and elections or the COMELEC. So Section 6, a free and open party system shall be allowed to evolve according to the free choice of the people, subject to provisions of this article. So this section emphasizes that the people have the freedom to develop and choose political parties as they see fit. The party system should be free and open, allowing for the natural evolutions of political parties based on the preferences and decisions of the people. However, this freedom is subject to the rules and regulations outlined in the constitutions. Section 7. No vote cast in favor of a political party, organizations, or coalition shall be valid except for those registered under the party list system as the provided in this constitution. So this section specifies that vote cast in support of a political party, organizations, or coalitions except those registered under the party list system, so will not be counted as valid. The only exception to this rule is for parties registered under the party list system as the outline in the constitution. Next is the Section 8. Political parties or organizations or coalitions registered under the party list system shall not be represented in the voters, registration boards, boards of elections, inspectors, boards of canvassers, or other similar bodies. So this section states that the political parties, organizations, or coalition registered under the party list system are not allowed to have representation in various elections-related bodies such as voters registration boards, boards of elections, inspectors, boards of canvassers, or similar bodies. These provisions aims to ensure that the impartiality and fairness of the electoral process by preventing an undue influence or bias from the political entities during elections proceedings. Section 9. Unless otherwise fixed by the Commission in the special cases, the election period shall commence 90 days before the day of elections and shall end 30 days thereafter. So this section says that the period of elections, unless specified differently by the Commissions, in certain situations starts 90 days before the actual election day and then ends 30 days after the election day. This time frame is set to ensure that all necessary preparations and activities for the elections can be carried and smoothly and efficiently. Next is the Section 10. Bona fide candidates for any public office shall be free from any from harassment and discriminations. So this section ensures that genuine candidates running for any public office are protected from any kind of harassment or discriminations. It guarantees that the candidates campaign and participate in the electoral process without facing unfair treatment or obstacles based on the factors such as their beliefs, background, or affiliations. The aim is to promote fairness and equality in the electoral process, allowing all qualified candidates to compete on an even playing field. Section 11. Funds certified by the Commission as necessary to defray the expenses for holding regular and special elections, plebiscites, initiatives, referenda, and recalls shall be provided in the regular or special appropriations and, once approved, shall be released automatically upon certification by the chairman of the commissions. So this section states that the commission or elections COMELEC is responsible for determining the funds needed to cover the expenses of regular and special elections, plebiscites, initiatives, referenda, and recalls. Once the Commission certifies the necessary funds, they must be included in the regular or special Appropriations by the governments. So once their appropriations are approved, the funds must be released automatically upon certifications by the chairmen of the commissions. So it ensuring that the necessary resources are available for conducting electoral activities. The Commission on Audit. Section 1. First is the Commission on Audit consisting of a chairman and two commissioners must be natural-born citizens of the Philippines, certified public accountants with at least 10 years of auditing experience, or members of the Philippine Bar with at least 10 years of law practice. So this ensures that the people overseeing government spending and finances have expertise in accounting or law. Second is the President appoints the chairman and commissioners for 7 years terms, with the chairman serving for 7 years, the commissioners for 5 years, and the chairman for 3 years, with no temporary or acting appointments. So these sections outline the appointment of a term limits for members of the commissions and audit. The president is responsible for appointing the chairman and the commissioners of the COA. So the chairman serves as the 7 years term while the commissioners serve for 5 years. Additionally, the chairman initially appointed serves for 3 years. So temporarily or acting appointments are not allowed, ensuring stability and continuity in the leadership of the COA. Section 2. First is the Commission on Audit is responsible for examining, auditing, and settling accounts related to the revenue, receipt, and expenditures of funds and property owned by the government or its subdivisions, agencies, or instrumentalities. This includes constitutional bodies, autonomous state colleges and universities, government-owned corporations, and non-government entities receiving subsidies or equity. If internal control systems are inadequate, the commissions may adopt measures. Second, the Commission has the exclusive authority to define audit scope, establish required techniques, and promulgate accounting rules, including those preventing irregular expenditures or government fund misuse. So this means that the Commission on Audit has special power. It can decide what areas should be looked at during audits. It can set the methods and approaches needed to carry out these audits. It can create rules about how government finances should be managed and accounted for, so including measures to prevent improper spending or misuse of public funds. These powers ensure that the COA can effectively oversee government spending and ensure accountability in financial matters. Next is the Section 3. No law shall be passed exempting any entity of the government or its subsidiaries in any guise whatever or any investment or public funds from the jurisdictions of the commissions on audit. It ensures that this section ensures that all government entities and investment made with public money are subject to scrutiny and oversight by the COA, promoting transparency and accountability in the use of public funds. Lastly is the Section 4. So the Commission must annually report on the financial conditions and operations of the government. So its subdivisions, agencies, and instrumentalities and recommend measures for improvement as required by the law.
Hello everyone, my name is Ben Clarence Morales Tarajos. I am from Group 7. And so for today's video, I'm going to explain to you the article number 10, which has 21 sections, and also the article number 9 under B with 8 sections. So now, let's dwell on. Now, let's begin for article number 10. So under article number 10, it's all about freedom of expression. So everyone of Filipino or the citizen in the country has the freedom or free to express ourselves. This right shall include freedom to hold opinions and receive and impart information and ideas without the interference by public authority and regardless of frontiers. So that could be the inside the article number 10, which is the freedom of expression. So for article number 10 under section 1, it's all about the territorial and political subdivisions of the Republic of the Philippines are the provinces, cities, municipalities, and barangays. There shall be autonomous regions in Muslim Mindanao and the Cordilleras as hereinafter provided. When we say autonomous, it is free country, it is free community for Muslim and also for the Cordilleras. So that would be this section 1. So for article number 10, section number 2, it's all about the territorial and political subdivision shall enjoy local autonomy. So it all means that this local autonomy is the exercise of certain basic powers by local government units as to best to serve the interest and promote the general well-being of their inhabitants. So that would be the article number 10, section number 2. So for article number 10, section number 3, it's all about the Congress shall enact a local government code. So it's all about that Congress shall provide for a more responsive and accountable local government structure instituted through a system which is the system called decentralization with effective mechanism of recall, initiative, and referendum allocate among the different local government units their powers, responsibilities, and resources, and provide for the qualification, election, appointment, and removal, term, salaries, power, and functions, and duties for local officials. So, on all other matters to the organization and operation of the local units. So for article number 10, section number 4, it's all about the President of the Philippines shall exercise general supervision over local governments. So it all means that provinces with respect to components of cities and municipalities and cities and municipalities with respect to component of barangays shall ensure that the acts of their component units are within the scope in their prescribed powers and function. So that will be the article number 10, section number 4. So for article number 10, section number 5, it's all about each local government unit should have the power to create its own sources of revenues and to levy taxes. So it is all means that this subject is to such a way of the guidelines and limitation as the Congress may provide. Consistent with the basic policy of local autonomy, such taxes, fees, and charges should accrue exclusively to the local government. So for article number 10, section number 6 is all about that local government units shall have a just share and as determined by law in the national taxes which shall be automatically released to them. So that will be the article number 10, section number 6 rather. So now let's begin for us article number 10, section number 7. It's all about the local government shall be entitled to an equitable share in the proceeds of the utilization and development of national wealth within their respective areas in the manner provided by law. So it is including the sharing the same with the inhabitants by the way of their direct benefits. So that would be the article number 10, section number 7. So for section number 8 is the term of office of elected local officials except barangay officials which shall be determined by law shall be 3 years and no such official shall serve for more than 3 years of consecutive terms. So voluntary renunciations of the office for any length of time shall not be considered as an interruption of continuity of his service and for full term or which he was elected. So for this section is all about the elected local officials should not exceed for 3 years in service. So it should be 3 years. Except for voluntary renunciations of the office for the any length of time, all should not be considered as the interruption of continuity of his service. So for section number 9, it's all about the legislative bodies of local government shall be have a sectoral representation as may prescribed by law. So that will be the section number 9. And for section number 10, it's that no province, city, or municipality or barangay may be created, divided, or merged, abolished, or its boundaries substantially altered except in accordance with the criteria established in the local government code and is subject to approval by a majority of the votes cast in a plebiscite in a political units directed affected. So that will be the section number 9 and 10 under article number 10. So for section number 11 is the Congress may, by law, or create as special metropolitan political subdivisions subject to a plebiscite as set forth in section number 10 hereof. So the component cities and the municipalities shall retain their basic autonomy and shall be entitled to their own local executive and legislative assemblies. So the jurisdiction of the metropolitan authority that will hereby be created shall be limited to basic services requiring coordination. So the main point for this is that the cities and also the municipalities should also to retain their basic autonomy or their freedom or their what is their free or the benefits should be entitled on their own local executive and legislative assemblies. So that would be the section number 11. So for section number 12 is that cities that are highly urbanized rather, as determined by law, and component cities whose charters prohibit their voters from voting for provincial elective official shall be dependent of the province. So the voters of component cities with a province whose charters contain no such provision shall not be deprived of their own right to vote for elective provincial officials. So that would be the section 11 and 12. So under section number 13, the local government units may group themselves, consolidate or coordinate their efforts, services, and resources for purposes commonly beneficial to them in accordance with law. So my interpretation for this section number 13 is that all of the local government who is running, they should be kept in mind and they should follow what is mandated by the government, especially the law. So, for section number 14 is that the president shall provide for regional development council or their seminal bodies composed of local government officials, regional heads of departments, and other government offices and representatives from non-governmental organizations with the region for purposes of administrative decentralization to strengthen the autonomy of the units therein and to accelerate the economic and social growth and development of the units of the region. So as a president, you need to provide for a seminar for all of the leaders of the all of one community, especially in a country, for example, in the Philippines. So as Marcos should mandated a meeting for the head, for all of the leaders to be united. Yes, for the social growth and development of the units in the region. So under section number 15, there shall be a created autonomous regions in Muslim Mindanao, especially in other areas of Cordilleras rather, and other shared common and distinctive historical and cultural heritage, economic and social structures in other relevant characteristic. So this one is more focusing on the Muslim Mindanao and other areas of Cordilleras. That it should have a autonomous regions. So for section number 16 is that the president shall exercise general supervision over autonomous regions to ensure that law are faithfully executed. So it is a responsibility as a president to exercise a general supervision over to look the autonomous regions, especially the Muslim Mindanao and the other areas of Cordilleras, that it should be to ensure that this law is well executed with that region. So that would be the article the section number 15 and 16. So for section number 18 is that the Congress shall enact an organic act for each autonomous region, such as Muslim Mindanao and also for other areas of Cordilleras. So with the assistance of and participation of the Regional Consultative Commission, composed of representatives appointed by the President from a list of nominees from multi-sectoral bodies. So that will be the section number 18. For section number 19, the first Congress elected under the Constitution shall within 18 months. So 18 months from the time of organization of both houses pass the organic acts for the autonomous regions in Muslim Mindanao and the Cordilleras. So for section number 20 is that within its territorial jurisdiction and subject to the provisions of this constitution and national laws, the organic act of autonomous regions should provide for legislative power over. First one is administrative organization. Second one is the creation of sources of revenues. Third one is the ancestral domain and natural resources. Fourth is the personal, family, and property relations. And the fifth one is regional, urban, and rural planning development. And sixth one is economic, social, and tourism development. Seventh, educational processes. Eighth is the preservation and development to the cultural heritage. And nine is such other matters as may be authorized by law for the promotion of the general welfare of the people of the region. So that will be the section number 20. So for section number 21, under article number 10, is that the preservation of peace and order. So with all of the regions shall be the responsibility of the local police agencies, which shall be organized, maintained, supervised, and utilized in accordance with applicable laws. With this, the defense and the security of the region shall be responsibility of the national government. So that will be all for the article number 10 and also its 21 section.